So let's go ahead and get started. So this is my disclaimer. I'm Claire Mambiella. I'm the library law consultant. I have a master's degree in library science and a law degree. My background is I was a law librarian for many years in law firms and academic and law schools. And because of that, and because my job now deals a lot with the law, I have a disclaimer just to remind people that even though I have a law degree, I'm not your lawyer, and that if you need legal advice for your particular situation, because every situation is a little different, the law can apply slightly differently, you should contact your lawyer. That the information I provide is more general legal information, and sometimes you might need something a little bit more tailored. So it's good to always contact your attorney. Here's my contact information. If I can ever assist you or offer you any information, please don't hesitate to contact me. We are back in the office one day a week. So I'm in the building downtown one day a week. The building, downtown Lansing, that is. The building is not yet open to the public. I work from home the rest of the time. So I am available via my office number at home, also email. So just don't hesitate to shoot me an email or a phone message, and I will get to you as soon as I can. I receive a lot of requests, but sometimes it may take a couple of days, but I definitely will get back with you. If you have an emergency, just say that in your email or in your voicemail, and I will act accordingly. Okay. A lot of the people on this call may be board members, it may be directors, but regardless, thank you. Thank you for working so hard for your community and for helping to provide the members of your community with library service, particularly board members. Michigan has always had board members. Michigan is one of the few states that have had libraries even before they became a state. Michigan has had statewide library service since since like 18, almost really pretty much since they let's see, it became a state in 1837. So actually before then. So we're a little bit unique in that way. Libraries have always been very, very important to Michigan. Libraries have always been locally controlled in Michigan, have always been an important part of the local communities, and have always required a library board. Library boards work for free, and sometimes you may feel like you're actually paying to work, if not in money, in sweat and stress. So thank you. It can be a very difficult job. It can be a very rewarding job, but it can be also hard. So just want to let you know, we very much appreciate it. If it wasn't for you, Michigan libraries couldn't operate. So what we're going to talk about today are public meetings. So we're going to kind of talk about a couple different things. So we're going to talk a little bit about the OMA, because that kind of is the shadow behind all open meetings in Michigan, behind all public meetings. And we're also going to talk about the actual kind of formalities of meeting, the actual running of a meeting. So particularly, we're going to talk about, when you have to have a public meeting. We're going to talk about why you have a public meeting. So what is the purpose of a public meeting? We're going to talk about the components of a public meeting, like what are the different parts of a public meeting that you have to think about. And then we're going to talk actually about managing a public meeting. So how do you kind of get your arms around being the one in charge of a public meeting, or just making sure that everything runs as smoothly as possible. So we start with the Open Meetings Act, and the Open Meetings Act is also called the OMA. Prior to 1976, when the current law came out, Michigan had more what's called a Government in the Sunshine Act, which is also what many other states have. So every state has some version of the Open Meetings Act or a Government in the Sunshine Act, and those acts, the purpose of those acts and what those acts are designed to do is to encourage public participation in government. So, all of us, if you took your civics class in high school or middle school, we all know that the United States is a little unique because it's, for the people, of the people, and by the people, right? So the way that the government in the United States is supposed to work is it's very heavily influenced by the populace. Okay, so this is carried down to the individual states. And the idea of the Open Meetings Act is to further encourage that. And part of the idea is that if you don't have a citizenry who knows what's going on in their government, they can't make proper decisions about who should be in their government. So the Open Meetings Act requires public bodies, and we're going to talk a minute about public bodies in a second, to make their decisions and have any discussions that lead up to decisions in a public forum. Okay, so in an area that is open to the public, that includes members of the public. So the idea is that you don't make decisions in secret. Okay, every decision and every discussion that leads to a decision made by a government entity or a public body is something that is completely open to, you know, members of the public. And one of the key things here is that the transparency is particularly important when you have a government entity or process where they can make decisions that affect operations of public entities, or in essence affect the running of the government or affect, you know, citizens' day-to-day lives. Okay, so think about things like, you know, you're the governing of your township or your county or your state. So when you have to have a public meeting, okay, because this, you know, this kind of gets kind of shady, right? It gets kind of a little bit convoluted. So a meeting under the Open Meetings Act, if you look at the statute in the, you know, Michigan legislature's website, you'll see that one of the first sections is definitions. And whenever you see definition section in a statute, you should, or an act, you should always read it, because legislation's all words, right? The whole thing about legislation is words. And when courts look at cases that are dependent on statutes, so if you were to be in trouble for the Open Meetings Act, right, and you were to have to, you know, go before a judge and have them determine whether or not you did something wrong, what the judge is going to look at is, what does the law say and what does each word require? So, you know, the meaning of words become very important. So to understand, or for a judge to determine, well, are you a public body under the statute? They have to look at the definitions. You know, what is a meeting under the definitions? Like what that would constitute a public meeting. So what the statutes say is, whenever you have a quorum of the public body, that would spark a public meeting, right? So that's one major component of the need to have a public meeting, whenever you have a quorum of the body. Now, you may think, why? Why is it that just because, you know, 5 of 7 of us are together that we have to have a public meeting? Well, the main reason is that decisions, for a decision of the public body to be official, right, to hold any weight, it has to be a quorum. You can't, you know, if you don't have a quorum, you can't make a decision, right? You can't decide policy, you can't, you know, approve purchases, you can't do your work. So having that quorum means you can make decisions. So you only can make decisions in a public meeting. So if you have a quorum, then, and you're together and you're talking, you know, the possibilities that you're going to talk about business of the library, you have to have a public meeting. Or if you're having discussions that are likely to lead to a decision that affects the operations of a public entity. So for example, you know, you think, well, if I already have a quorum and I have to be there, what does the decision thing matter? Well, let's say you have a committee, right? Let's say the board, you know, designates a committee, you know, maybe it's a hiring committee or a personnel committee. And the personnel committee is charged with looking at resumes, right? Well, if the committee is charged by the board with taking all of the resumes that come in and whittling them down to a certain number of candidates, so if they're charged with deciding which resumes get to the board for final determination on who gets an interview, then that's a decision. And that decision, you know, since the board delegated to the committee its authority to make that decision on those applications, because the legislation gives the board the authority to hire, you know, let's say a director and their assistants. Okay, so if the board designates that authority to a committee, and the committee, in order to do its job, has to make these decisions, then, you know, firm decisions that are going to cut people out of the running, then those committee meetings have to be in a public meeting, even though they don't have a quorum. If that committee is charged with just, you know, making recommendations, so if that committee is told, okay, take in all the applications, look at them, and put them in 4 piles, you know, these are the people that we don't recommend. These are the people that, yeah, we think they might be okay, but maybe we have some questions. And this is the group that are spot on. So if you give them, if the committee gives those piles to the board, and so no resumes get tossed out, they're all there, they're just organized, and they get sent to the board during a public board meeting with a recommendation when the committee makes its report, then the committee does not have to meet in public again, as long as it does not have a quorum. So that decision piece can be important in situations where maybe a quorum isn't needed, but the board has delegated some powers or some expectation of a decision. When a decision, excuse me, I'm sorry. Essentially, if you're a public body and you have a quorum, the idea is that you're probably going to make a decision. So since when you make a decision, you have to be in a public meeting, you know, a public meeting is going to be required. And if you're a committee where you don't have a quorum, but you're charged with making a decision, that would also be a public meeting is required. So let's talk about what a public body is. So the statute, again, defines public body by a group or an entity that is empowered by the state constitution or a statute, charter, ordinance, resolution, or rule, to exercise governmental or proprietary authority or perform a governmental or proprietary function. So essentially what this means, that's a direct quote from the statute, is that if you're an entity that was created or established by the Constitution, by a statute, by a charter of your municipality, by a municipal ordinance or municipal resolution, or some kind of, you know, either state or local rule, and you're a governmental entity, so you were created by a governmental entity, and your job is to perform a governmental function, then you're considered a public body. And libraries meet all of those standards. Libraries are created by statute. Libraries are also partially created by charter, ordinance, or resolution, depending on what type of library you are. And you do provide a government function. You do provide a governmental function, because the law in Michigan is that libraries, you know, are local. So essentially, any body that offers a government service and is created by statute or some form of the law is considered a public body. Now, the purpose of a public meeting. So the purpose of a public meeting is, remember, if this whole idea of the Open Meetings Act and this whole idea of, you know, meeting in open is to permit members of the public to observe their government and participate in the government. Okay, so it's designed to promote and encourage transparency in the workings of government. So, and then it also requires members of the group, of the governmental body, to confront members of the public and to make those decisions in open and debate those decisions in public in a forum where members of the public can also have a say. So it takes government out of the shadows, right? It heavily discourages backdoor decision making and kind of decision making in secret. And the purpose is to bring, that's why they call it government in the sunshine. The purpose is to bring governmental work into the light and expose it in all of its, kind of ugly details, like they say, the sausage being made, to members of the public. So members of the public, if they wish, can participate and question and be a part of this process, because the fact is they pay for it, right? So what are the pieces of a public meeting? Well, the first piece of a public meeting is the type of meeting, right? The format of the meeting. Is it going to be an in-person meeting or a virtual meeting or a hybrid meeting? And this has become more of an issue in the past year. Your planning and your notice of the meeting, right? So once you determine the type of meeting you're going to have, you then have to decide, not only, when you're going to have it and where you're going to have it, but also you have to make sure the members of the public know you're going to have it and where it's going to be, and that if they have a disability, that disability will be accommodated, that they're welcome, and any other information that they need to participate in that meeting. You may want an agenda. Now, agendas are not necessarily, they're not required by the Open Meetings Act in Michigan. The law does not require an agenda. However, if you do a little bit of research into parliamentary work or into board meetings and best practices, you'll see that most entities suggest an agenda. An agenda is really kind of considered a best practice. And, a lot of you, if you work outside the home, you probably know that if you have to have a meeting, an agenda can be very handy, because an agenda not only lets everybody know what's going to happen and the order in which it's going to happen, it can help keep things on track so that members don't kind of get, sidetracked down tangents, or don't bring up things that are not meant to be dealt with at that particular meeting, so that a meeting doesn't run too long and everything that needs to be accomplished is accomplished. So an agenda can actually assist with the transparency piece. It also provides a record, right? Just like your meeting minutes do. And then there's rules. And this is a part of public meetings that does not get a lot of discussion. But I think especially nowadays, where there are many areas where there's contention, and there is a lot more, for lack of a better word, stress and anxiety going on, both at the municipal level as well as around members of the public, that rules can be extremely helpful. And they don't have to be onerous. Like, rules don't have to be a bad thing. Right now, that may just me be saying it because I'm, I have a law background, and most lawyers like rules, right? Makes everything kind of tidy. But rules can be very, very useful, because it helps people know what to expect, and it helps people know how to behave and what to do. So procedural rules are important, and a lot of times that's your parliamentary rules. Now, again, with public meetings and the Open Meetings Act, a lot of people don't talk about parliamentary rules, but we all kind of know about it, right? So we're talking about Robert's Rules of Order, or Sturgis, or there's some others. If there's a National Association of Parliamentarians, and their webpage has, I have links in the resource pages attached to my slides here, but that has all kinds of helpful tips on parliamentary procedure. MSU Extension has some courses on parliamentary procedure if you're interested in that. And the nice thing about parliamentary procedure is that you can go as strong or as weak on it as you want. right? So you don't have to be an expert in Robert's Rules of Order, which can be extremely complicated and bureaucratic. So, but it can, usually the smaller your group is, the probably less likely you will be to have real strict parliamentary rules. But the best thing about the parliamentary rules is it's really can help move a meeting along, and it can help keep members of the board in check. It can act as kind of a boundaries for those members of the board to let them know this is how things are supposed to work, so that again, meetings don't necessarily go off the rails. And it adds a certain amount of formality to the proceedings, which can also encourage civility and professionalism. And then you have behavior rules, right? So these are your standard, you know, a lot of libraries, you know, you have your, you know, patron behavior rules or patron behavior policies. Well, this is not that much different, but they're not quite as detailed and as lengthy. So your, you know, behavior policies would be more along the lines of conduct and ethics. And these can apply to members of the board as well as members of the public. And then you have public commentary rules. So these are the rules that govern the part of the meeting where members of the public are able to speak. And we're going to go into more detail on these in a minute. And then you have your minutes, right? So this is your record of the meeting. And the Open Meetings Act has certain requirements for what have to be in minutes and how when the minutes get posted, and not a whole lot on where they're posted, but some on where they're posted. And so we're going to discuss that as well. So let's talk a minute about form. So this would be in person, virtual, or hybrid. And each of these have different pluses and minuses, right? So with in-person forms, you know, you have to make sure you have your venue, that you have your day, time, you know, you have your, you're on point with accessibility, right? Because the Open Meetings Act says nobody can be turned away, right? So if you have a meeting room that only holds, you know, 20 people and you use like a room in the library, but 21 people show up, you have to, you know, you cannot stay to that 21st person. I'm sorry, nobody else will fit in here. You have to cancel the meeting or move to a larger space. So you can move to a bigger room, you can move to the reading room of the library if that's practical, but you cannot turn anybody away from a public meeting. So that's an important consideration when you're thinking about in person. I also want to kind of make a note here that part of the planning and part of this is, as I said, you're deciding when and where to have your meeting. And there are certain rules about that that we'll get to, but when you're thinking about when and where, one thing to consider is, remember, this is all about transparency and the encouragement of participation in government. So if you're having your public meetings at a day and a time that is very inconvenient, or would be largely inconvenient to the broadest number of your constituents. So for example, if you're in a community where the demographics show that you have a large number of working people, then having it at 2 o'clock on a Tuesday afternoon may not be the best choice in terms of encouraging community participation. And, you know, having it at a time that you know is a time when most people can't come is certainly not you know, it may be holding to the letter of the law, but it's not holding to the spirit of the law. And in the end, part of, you know, why we're here today, and part of the purpose of training in these kinds of issues and adhering to all of these issues is, yeah, okay, it's part of the law, but it's also part of engaging your community and building trust. Because if you want that millage, if you want that new building, you know, if you want to work really well with your municipality and you want members of the public to support the library and volunteer in the library, then, you know, you also have to encourage them and enable them to participate in the business of the library, and open meetings is the way to do that. So, you know, having your open meetings at a time when members of the public are likely not to be able to come is not the best way to build trust, right? Virtual meetings. Well, right now, according to our OMA that was recently amended, virtual meetings can only be held by a public body until December 31st, 2021, if that public body is located in a municipality that has an emergency order out or a state of emergency. So there are some that still have that. There's many that have dropped them. If you did have one, you might want to make sure that it's still in effect. If members of the body can only participate remotely, if there's a state of emergency, either where they live, the municipality they live in, or the municipality where the library usually meets. So if it's where the library usually meets, I'm sorry, where the board usually meets, so for example, if it's where the library is, then the whole board can meet virtually. If the state of emergency is only where the certain board member lives, then only the board member can attend virtually. Board members individually can attend virtually if there's a health issue. So if they have an injury or a disability or an illness that would prevent them from attending in person. Or if they're a member of the military on active duty or on duty as part of their military service. Those are the only three reasons that an individual member can attend. If they're in after December 31st, 2021, the only option left for remote attendance by a member of the board would be military service. So one of the questions we've been getting a lot is, you know, prior to the pandemic and prior to these changes in the OMA, Michigan had loopholes in the OMA as far as remote attendance. So it had not been decided either way whether members could attend remotely. And so many libraries had bylaw provisions that permitted board members to attend meetings, say from residences that they may have owned in other states, or while they were on vacation, or their cottage in another part of this state. Well, that no longer applies. So if after December 31st, 2021, if a board member is not on military duty, they cannot attend remotely, period, unless it's an ADA accommodation. Until December 31st, 2021, a board member can only attend remotely if there's a state of emergency where they live, if they have a medical condition, or if they are in military service. So that's a big change for Michigan. There are several libraries that have board members that attend remotely. So that's something to really, you know, consider when you're planning your public meetings. I'm on a committee for MLA for legislation. And we, you know, one of the things we're hoping to do is talk to some legislators about possibly, you know, making it so libraries can meet remotely, but the legislature right now is really not in favor of remote attendance. So we'll see. And then the other thing about virtual meetings is there's technology involved. So your library has to make sure their technology is on point in order to comply with, you know, every member of the public has to be able to hear every member of the board and hear clearly so they know who's voting and how they're voting and what decisions are being made. Are you going to record it if it's virtual? And if you're going to record it, are you going to post it? And where are you going to post it? And for how long are you going to post it? So those are some questions. The Open Meetings Act does not require you to record it. It does require minutes, but it doesn't require you to record it. So if you are going to record it, though, you're going to want to check to see how long you may have to, you know, keep that recording up, or, you know, what if there's any negative ramifications of that for the library. And that could just depend on library by library. Largely, probably not, but some of it could depend on what's going on at your library. And then, there's some additional statutory requirements in the OMA with regards to how these meetings are conducted virtually. There's some additional announcements that need to be made. And so all of those things need to be considered. And then there's the hybrid kind of a meeting, which is, maybe the board is meeting in person, but members of the public are attending remotely. And this is kind of a new loophole in the law in Michigan. There's nothing that says you can't do this. Okay, so there's nothing that says that the board can't be there in person and the members of the public be there remotely. The problem is that you need, again, to make sure that your technology is up to the task. Because not only do you have to, as I said, not only do you have to make sure that members of the public can clearly hear everything that's going on, but that members of the board also have to be able to clearly hear members of the public who are speaking in public comment. So it is kind of, you have to make sure there's two-way communication, two-way clear communication. And then also there's accessibility issues with both of the virtual. What if you have people who are hearing disabled, or is your technology going to be compliant with the web accessibility guidelines? Do you need an interpreter for, sign language, or, some other, do you need captioning? Something else that would, be able to accommodate some, different members of your public with different disabilities that may make it difficult for them to do online. Then the other flip side of this is if you're having an in-person meeting, there may be members of the public who cannot attend in person because of a disability. And then there may be an accommodation for a virtual option that may need to be put together for that member of the public. The good thing is, or not the good thing, but the other, another facet of this is that if a member of the public needs an accommodation, it's up to them to reach out to you and say, I'm hearing impaired and I need this accommodation. So, you want to be able to be ready to supply these accommodations, but they don't necessarily need to be supplied all, right away. I would suggest that if you are doing anything virtually, if you're having a hybrid meeting, that you check to see if the platform you're using has the ability for a written transcript or captioning, because that would be the least thing that you would want to offer. And you may want to just turn that on now and let your public know that it is available. Same thing with recording with the hybrid. And the additional requirements still apply. So you may have to do some additional announcements. Roll call votes would be necessary with a virtual environment. So you couldn't just have a show of hands when you do votes. And, this is, like I said, a gray area. So, if you're going to do this, I would check with the attorney, your attorney for your library, and see what their opinion on this is. Because again, depending on, the culture of your community, depending on the technology available to you, it may be a good idea for you to do hybrid. It may not be a good idea to do hybrid. It may be risky if you can't absolutely comply with all of the requirements. So planning and notice. So the OMA is very big on notice. The OMA requires, and some of the library establishment laws require, that boards have to schedule at the beginning of the year. So it can either be one statute requires within 10 days of the first meeting in your calendar or fiscal year. The board has to sit down and figure out, or in that meeting, they would sit down and figure out the days that they're going to meet for the year. All right, so the schedule of board meetings for the year. And then within 10 days of that meeting where their schedule was approved, they have to then post that. Now, what if something changes because stuff happens? Then they would have to then repost according to the Open Meetings Act in order to get the new information out, within, I think it's, I want to say it is within a few days. It's in the statute. I'm sorry, it just blanked out. That it actually might be, I know I'm second guessing myself, but anyway, there is a, it's a shorter amount of time within the time that you agree to that change. You have to post that change. And I actually think it might be like maybe a day that you have to post that change to your annual schedule. Changes, any kind of change is subject to an additional notice provision, especially if you're doing an online meeting. If you have a special meeting that, you can notice a special meeting 18 hours in advance. If you're going to do that, then you have to post that on your website. You can't only post it in person or in physical location. You also have to post it on your website. There's actually a very recent OMA decision against a municipality here in Michigan, where the municipality got in trouble because they did not post it on their website, their notice of a last minute change in a special meeting. Notice required, you have to make sure that, the notices for a virtual meeting are different than notice for a public meeting. Virtual meeting requires more information. So, you want to make sure it also requires, if you have an agenda, you have to post the agenda electronically, whereas an in-person meeting, you do not. You want to make sure, the law says that the notices have to be posted in the physical location where the body is headquartered. So for example, your library, but then also in any other location considered appropriate. So, and again, this is one of those things that think about the purpose of the law, right? Transparency and encouraging participation in public meetings. So, your notice should probably, if you do have a website, put it on your website. That's the easiest thing to do. And that's probably will cover your butt, so to speak, if you post it in a physical location and you post it online. Post it if you are a library that is also governed by a municipality. You're probably also going to want to post it in the town hall, or another municipal location in addition to the library. If you choose to have an agenda, as I said, it's not required, but it is recommended. We always said agendas are very useful in maintaining order. Your agenda should be available to the public. So again, if you're doing a virtual meeting, the agendas have to be posted to the website. If you're doing an in-person meeting, you really should have copies of the agenda there for members of the public. Because again, the OMA is not about hiding stuff from the public. If you are having a public meeting, but you don't want to give an agenda to members of the public, then there is something wrong. Okay, that's a problem. The members of the public are entitled to an agenda. It is public record. So just give it to them. Again, part of this is building trust with your community. You can amend the agenda in meeting if it's necessary, and you don't have to worry about, giving the public the amended copy. That's okay. But, if you walk into the meeting with a copy of the agenda, make sure members of the public also have the opportunity to have copies of an agenda. So when you're looking at your agenda, the Open Meetings Act does not have any requirements. In fact, Michigan does not have any law that requires that your public meeting be structured in a certain way, right? So we've all, in public meetings, if you've been to your community, like your township meeting or your county meeting or your city meeting, you all know that a lot of them kind of run very similarly, right? So they start with a welcome, and then sometimes there might be an invocation or a pledge of allegiance, and then they might, start with approving the agenda, and then go into, reports, and then then old business, then new business, but that's not set in stone. Okay, the board can arrange the components or the parts of a public meeting as the board wants, as it works best for them. Very often, the parliamentary scheme that you decide to use, whether it's Robert's Rules or Sturgis or one of the others, can offer some guidance in that. Again, there are a lot of websites on parliamentary procedure that can tell you this is the best practice way to run a meeting. The Michigan Municipal League and MSU Government Extension also have information on public meetings and best practices and ways to run them. Again, when we're talking about the agenda, a lot of it just depends on comfort level for the body. So this is something that can be in your bylaws, is what is the format of your meeting going to be. The one thing you're going to have to do is you always want to include public commentary, and you're going to want to make sure that you approve your prior minutes. In addition to any kind of business you have to deal with to do a vote. But public commentary is key. You have to include public commentary in every public meeting. And same thing where you're going to want to approve your prior minutes, because the clock is ticking, right? You have the 8 days for the draft and the 5 days for minutes that are approved. And if you're going to have a closed session, you're also going to want to make sure that that is also on the agenda. So a sample agenda might look like this. So you have your greeting and your start of session where the chair welcomes everybody and formally starts the meeting. And then you have a roll call for the, and I may have used the wrong word, roll there. You want to make sure that, you take attendance, right? Everybody who is there, and everybody says present. If you're online in a virtual environment, you have to announce your name and the city or county that you're from, or that you're broadcasting from. And that has to be put in the minutes. Then, you can have a call for an agenda change or an agenda approval. And then everybody would vote on the approval of the agenda. If there's any changes, they would have to, discuss the changes and then approve them. You could have reports from committees. So if your board has committees, so if you have a finance committee, or you have a personnel committee, or you have a facilities committee, and they make monthly reports at your board meeting, or they're working on some project where they're making a report, you could do those reports together at a time during the meeting. If you have, your director's report could also be during this time. And then, of course, the board is open to asking any questions of the people making these reports, if they have any. Then once that's all concluded, then you can go on to old business and wrap that up, and new business. And remember, motions, and there'd be debate and discussion before decision. And then you could do public comment. Now, public comment, there is there's many different feelings about public comment. There is a certain point of view that says public comment is best at the beginning of the meeting. There's other proponents for having public meeting in the middle of the meeting. And then there's other advocates for having public meeting at the end of your meeting. So it really is up to the board, up to the body to determine how they want to structure public comment. You can have rules for public comment, as I mentioned, and we're going to go into that, but public comment cannot be limited to a certain amount of time. Individual people's statements can be limited to a certain amount of time, but not the total. So every member of the public that wants to speak has to be able to speak. So depending on the situation at your library, you may decide that public comment maybe is going to be at the end, because it might go on for a while. And people who were there just to attend the business part of the meeting then could leave. But as I said, there are some people that like to get it done up front, and that it just really depends on you. As long as you have it, it doesn't matter when you have it. And then at the end, you announce your next meeting date, and then you can formally adjourn your meeting. So let's talk about rules. So when I talked about rules earlier, there are certain reasons to have rules, right? And as I said, I'm a big proponent of rules. And rules, a lot of people hear the word rules and they hear bad things. They think, yuck, rules. But rules can be very useful because they keep order, because they set expectations. of both the members of the public and other board members as to what's going to happen, how it's going to happen, and how people should behave. It can provide a formal way to handle conflict. So if your board is in a community or is in a particular situation where there is some controversy in your community or with your library, having these rules can be a very handy go-to to handle any kind of conflict that arises within the meeting, whether it's a member of the public or whether it's a board member or more than one board member that are going at it. It allows the chair to have some tools to use to kind of tamp down any conflict in order to maintain a safe and a productive space. It can create a space, conducive to public discourse. So if you have an environment where there's no rules and everybody's just kind of doing what they want, then that is not a space conducive to getting business done and to public discourse, to members of the public understanding why the board is acting in a certain way. And it's not conducive to the board understanding the public's reaction to that and hearing what the public wants in their public library and what the public doesn't want in their public library. Because, we all know that sometimes having that public discourse can be uncomfortable. And we have all been in situations where we've been confronted by members of the public that are not happy with something that's happened, or they're frustrated and they take it out on the public body or they take it out on individual employees, and that's not pleasant. But at the end of the day, the good outweighs the bad as far as the purpose of public meetings. So it's important, and again, part of the gratitude of having you all be board members is that we know that it can be hard and we know that it can be uncomfortable, and yet you still step up. And the ability to do that is very important, and it is valued, even though some days I'm sure that you don't feel that way. And it can be very tempting to do what you can to escape that. But unfortunately, it's a very important part of our democracy. It's a very important part of the way governments work. And it's a very important part of connecting with your community as a library. And so, having these rules can really assist you in some of the more uncomfortable parts of your job. So the first kind of rule that we're going to talk about are the parliamentary procedure rules. And again, we mentioned these a little bit. Parliamentary procedure rules can be extremely complex. One of the purposes of parliamentary rules is to address conflict between members of the body. So one of the things that's really useful about parliamentary procedure is that it reinforces this idea of, two members or more of a public governing body can get heated and can disagree, but there are civil and intellectual and professional ways to do it. And that's what these rules kind of support and reinforce. I would recommend that once your body chooses the parliamentary procedure you're going to use, that every member gets some kind of training on it. Again, it doesn't have to be, not everybody has to be an expert in it, and you don't have to use every single part of Robert's rules. Okay. I have a copy of Robert's rules right here. And it's pretty thick, even in a paperback, and the words are kind of tiny, but it has a great index. There's even a Robert's Rules for Dummies, those books it's like Cliff Notes for Robert's Rules. And again, you can just flip to the index and look up debate, and then it gives you, here's the debate sequence. So you don't have to be an expert in every part of the rules, right? And so that I highly recommend that, if you're experiencing issues among members, order a copy for each member of Robert's Rules. They're not tremendously expensive. In fact, if you shoot me an email, the Library of Michigan has some, and I will send at least one copy to your library, so that you have at least one copy of Robert's Rules of a new version. And then maybe ask your director or your secretary, or if there's someone on your board who is a parliamentarian or who is, some people are very interested in this and are very good at it. So if you have someone on your board who is one of those people, ask them to create a cheat sheet for your board. You can even pull them online. So I have some links to some, and they're like a little Excel sheet page, and it tells you, here's how to make a motion. Here's how to, propose new business. Here's how, to do a vote. And it's very succinct and it's very easy to read. And just make sure each member has one for those rules that you do want to implement for parliamentary procedure. And that way, during a meeting, if they're not sure what to do, they can pull that sheet out and there it is, so that they can, again, follow the rules and act appropriately, but they don't have to be worried that they have to memorize everything. As I said, your body can determine how much you want to get into this and how loose you want to be. And I would recommend that you put that in your bylaws, that this is what we decided and this is what all of the members are going to follow. Behavior rules. So this is, you want to set guidance and boundaries for actions of the public and members of the body. And I'm sorry to say, this is more and more, I'm getting questions about this. People's patience, I think, is very worn down from the pandemic, from the political situation. I think a lot of people are frustrated. I think a lot of people are anxious. I think a lot of people are tired and burnt out, and that's starting to come out, right? So in order, the board's purpose is you have to have a public meeting, but you also don't want to be there for 3 days, right? All of us have sat through meetings that last hours, and not fun, not productive. They can be awful. So having your behavior rules on top of your parliamentary rules can help streamline your meetings, can help empower your chair to keep people in line when necessary. And as I said, it also puts people on notice. It sets the expectation for both members of the body and members of the public that, hey, we want you here, we're glad you're here, but we have a certain standard here of behavior and decorum and civility, and this is how everyone is going to act. So you can restrict actions of the body, right? So you can determine if your members, either as part of parliamentary procedure or behavior, if members of the body have to stand to speak, or if they can speak from their chair. You can have, you can require that members of your body put their phones on silent during a meeting or turn them over. It is not a good idea for people to be texting during meetings anyway. So you can even have a rule that tells your members of your body, put your phone away during the meeting. Your phones are not permitted during the public meeting. They're not permitted on the table. They have to get put away. So you can restrict actions, but you cannot restrict speech, right? So you can't restrict what someone's going to say. And that includes members of the public. So you can't tell people not to use profanity. You can't tell people that they can't, that they have to be nice. They have to, they can't criticize or say mean things about people, because that's freedom of speech. If a member of the public wants to get up and tell the board that they are a bunch of blanks and they are doing a blank job and that they hate them, then that's, that's the First Amendment. they can do that. So, what you want to do is control behavior, but speech, you have to let go. Speech. Now, members of the body, right? So members of the public are one thing. Members of the body, you can say as part of your you know, the body's rules that that you can put in your bylaws, you can say, you know, you have to stick to the topic that's under discussion. You can't go off on a tangent. You can't bring up things we did last year. You can't bring up a business that, you know, is already concluded. You can't bring up past business. So you can have some alternate rules for the body, but you can't have restrict speech on the public. If your municipality has an ethics ordinance that public officials are bound by, many in Michigan do, not everybody, but if your city or your township has an ethics ordinance that the township officials or the city officials have to abide by, chances are those would also bind the library, unless you're a district, but there could even be an argument for that. So I would recommend that you take a look and see, because those ethics rules would also apply, and those are something that your members should be aware of. You can tell the members of the public in your rules that if they violate these rules and that results in disruptive behavior, then they can be removed from the meeting. And that's a discussion you can have with your law enforcement. What constitutes for the law enforcement in your area, what constitutes public disruption. But, you know, that can be shouting. It can be if there's threatening physical you know, behavior, like someone rushing forward to the board or trying to put their face in the board's face, or, you know, there are things that can constitute public disruption. If they're preventing other people from speaking, you know, again, if there's a large body of people, like a group, an activist group that is there and causing disruption to the level that other people can't participate in the meeting, or they're interfering with those people's ability to learn and to participate, then that could be a disruption. So this is a conversation, again, you could have with your law enforcement to say, okay, at what point can we boot someone out of a public meeting? But it definitely can happen. And if your members of your body are violating the set rules, then there should be consequences for them too. And that can be in the bylaws. So you could say, all right, you get 3 strikes. If you violate, you know, the decorum rules, you know, more than 3 times, then, you know, X is going to happen to you. Maybe it's you lose a committee assignment. Maybe it's you lose the ability to discuss. You know, there could be certain things. There's certain things you may not be able to do, like you can't prevent them from voting. But you know, again, there are consequences that can be given to board members who are not, you know, who are flagrantly violating the rules. If worse comes to worse and they're an officer and they're becoming a real problem, make sure your bylaws have provisions in them that say, okay, this is how an officer can be removed from office. And I don't mean taken off the board, because that's a whole other thing. I mean, if your secretary or your president or your vice president or your treasurer, well, you're no longer vice president. If you're going to continuously violate these rules, we can remove you as vice president of the board, or we can remove you as president of the board. So those are the kinds of sanctions that, you know, you may want to seriously consider making sure your bylaws have in there. So an example of some behavior rules. So as part of law school, I've taken, you know, mediation and alternate dispute resolution. I've also attended some trainings on facilitation and mediation. And one of the really good trainings I went to had the suggestion that when you're in a situation that you may be expecting some contention, but I actually think that this is useful all of the time, because again, it sets an expectation, and after a while, people will just get used to it. So in your meeting room, post your meeting rules, right? And these apply to members of the governing body, can also apply to members of the public during public comment. So your phones are on silent. This is a safe space, so that means anyone can say what they need to say without fear of retribution or judgment. Everyone will get a chance to speak. So whether you are a board member and you want to weigh in, or you're a member of the public at public comment and you want to say something, everybody will get a chance to speak. So you don't have to be worried or yell, or everyone will get a chance to speak. Only one person can speak at a time, whether you're a member of the public or you're a board member. You may feel strongly about something. Someone may be mad because you're saying something that they believe is not correct, but you have to hold on to what your statement is until the other person is finished. You have to listen, right? And this is particularly important for members of the board. You have to stop and listen. It can be very easy in a debate situation to just be waiting for your next time to speak, right? Because you know what you want to say and you know what you're saying is right. You have to listen to what the other person is saying. You have to stop and you have to take a deep breath and you have to listen. You also have to step back, okay? Part of being on a library board, right? Library board is not the city council. It's not the township supervisor. It's not the state legislature. It is a library board. You're there to support the library. Your primary duty is to act in the best interest of the library, not in the best interest of the city, not in the best interest of the township, not in the best interest of the county, not in the best interest of your political party, not in the best interest of your religion. It is to act in the best interest of the library. And the library represents everyone, not just people like you, right? So you have to be able to step back and let go of some of your own personal preconceived notions and biases and preferences. And that's very hard. Believe me, I understand. But you have to act in the best interest of the library, even if you're an appointed trustee. The city that appointed you, in very, very few instances, the city that appointed you is in charge of the library. 95% of libraries in the state have a library where the municipality created the library, and the municipality may appoint a board, but the municipality has almost no authority for the running of that library. So the law did that on purpose. And so the library, the board, the governing board of the library is there for the library, not for the municipality. And that is very important. So you really need to take a deep breath and step back. Not only will it help discussion, but it will help your mental health. Trust me. You want to attack the problem and not the speaker. If a colleague is debating something that you know is wrong, or that you know is not good for the library, then you want to take them down by taking down what they're saying, not insulting them personally, not offending them, not denigrating them. You want to do it with your logic and your argument on the issue. And the same is true with a member of the public. If someone is attacking you personally, first of all, in public comment, you shouldn't talk back. You should just take it. And I know that's really tough, but it's not good to speak back in public comment. You can, you can offer to address it later. You can offer to, say, look, I'd be happy to send you an email or respond, but you do not want to get into a debate with a member of the public in public comment. You can say that, words that incite violence or that threaten will not be tolerated. Now, this is dicey because you have to be careful. You cannot regulate speech, right? Because that's a First Amendment issue. But there's a very gray area, when people talk about hate speech, okay, which is right now a very, very hot button issue right now. In public libraries, it's and in governmental institutions, it's difficult because the First Amendment is tantamount, okay? So what most people call hate speech is actually protected by the First Amendment. And believe me, I'm the messenger, okay? But that's the way it is, okay? So That's why if it raises to the level of threatening or inciting violence is where you want to draw the line. So if someone's, all blank people should be killed, all blank people, have no worth. If there's blanket statements or there's statements that could incite violence, that's where you would draw the line with speech. But again, you have to be careful because that First Amendment rule is absolute. You want to keep an open mind, right? You may feel strongly about something, but we all learn something new, right? So again, take a deep breath and hear people out, because you may decide, hey, you know what? Okay, maybe okay, maybe we could do that. Respect each person's experience, expertise, and perspectives. Again, nowadays, it's very easy to have certain concepts about other people, but take a deep breath and respect why they're there. Even if it's a member of the public that's yelling at you, you can say, well, this is a person that obviously cares very much about their community and cares very much about their children and cares very much about what their child does at the library, even if what they're saying is something you vehemently disagree with. So, it can be helpful when you're managing issues to try to meet people in some area where you can agree, right? So, okay, you can say, well, we both care about the library, and that can help you in your mind say, okay, I'm going to handle this. I can handle this. Or if you're debating something with a colleague that, again, you disagree with completely, you can also say, okay, well, we both are here and using our own time away from our families to do this job of board members. So we both care about the library. We both have a reason for being here. Let's see where we can meet and move from there. And then finally, everyone abides by agreements that are made. So all members of the board, once a decision is made, once a vote is taken, every member of the board supports that vote, even if they did not win, even if their perspective was not the one that prevailed. You don't walk away from a public board meeting where it did not go your way, grumbling and complaining about it. Once a vote happens, and if it is not in your way, you support the board's decision. Because remember, a board acts as a unit, right? A public library board does not act as individuals, right? You have no authority individually. Your authority comes as a unit. And I don't care if you're the board president. I don't care if you're the board treasurer. You have no, statutorily speaking, the statute that gives you your power, you have no power as individual people. Your power and authority come as a group. So when you as a group make a decision and the majority speaks, it is the job of every other board member to support that, even if you don't like it. Your rules for public comment. There are some rules you can have for public comment, again, to help you manage public comment. You cannot require that people attending the meeting as a whole register or sign up or give their name or address. They don't have to. Anybody can show up to a public meeting. They don't have to identify themselves. But if they want to speak at that public meeting, then you can require that they identify themselves. I would caution against requiring them to give you their address because that becomes kind of a personal information issue. You can ask them to give you their county or their township, something broad, but I would not ask them for their specific address or telephone number. You can also limit the amount of time they speak. So you can limit individual, like a lot of libraries say, okay, you have 3 minutes. So you can say each speaker has 3 minutes. So that if you have a huge number of people, you're not there all night, right? So, and it also, if people tend to rant or you have someone who's going off on tangents, that 3 minutes cuts them off. You cannot restrict what they say, unfortunately, but you cannot. Minutes. So who takes the minutes? Oh, and the one more thing about rules for public comment, you want to make sure that those are publicly available, that you post them, or you may want to announce them at the beginning of your meeting. You may want to have, you could post them in the room like you do the other rules. You could have a handout for people, but you want to make sure members of the public are aware of what the rules are. So now minutes is the last thing. Who you want to make sure, you want to have your procedure for who takes the minutes. If you have a secretary and you're requiring the secretary to take minutes, keep in mind that it's going to be difficult for a secretary to take minutes and participate in the meeting. So you may want to have someone else take minutes, the library director, or you could have a staff member from the library come and take minutes and pay them for that time. But having someone who is not a member of the public body, who does not have to conduct that business, is probably best, so that every member of the public body can be engaged. Decide what you want in the minutes and the format of the minutes. The Open Meeting Act requires that date, time, place of the meeting, the attendance, so who was there, any decisions that were made, any roll call votes that were taken, and if you have a closed session, the reason for the closed session. So those are the required components. I would also recommend maybe that you put a few extra things in there to add context, but that is up to you. And this is one area where many lawyers who represent libraries and represent municipalities may differ from me. I look at meeting minutes from a research perspective and from a contextual perspective, because I actually go in and I read a lot of minute meetings looking for things like hints on how a library was established, or the history behind a certain conflict, or what was going on. Whereas, many, your attorney may say, well, you put the least amount possible in there. So in other words, something that couldn't come back to bite you later, or something that couldn't be used against you in a lawsuit. That is all up to you. As I said, the Open Meetings Act has some requirements. My perspective is that if your minutes are going to be so bare that there's nothing to them, then to me, what's the point of having them? But again, that is completely up to the board as to how they want to do that. Consider where you post your meeting minutes. The law requires that you have them physically available in the library, so that either you can make a copy for a member of the public that requests them, or you keep copies of the current minutes. The FOIA, Freedom of Information Act in Michigan, and records retention laws require that minutes of public bodies are kept forever. So your meeting minutes are kept in perpetuity. That means that you never throw them away. So a member of your public should be able to walk in and get a copy from your minutes from 10 years ago if you existed at that time. You may want to consider posting them online. Remember, the Open Meetings Act came out in 1976, way before electronic life as we know it. I would strongly encourage that you post your minutes electronically. It makes it easier for members of the public to access. And what's the purpose of the Open Meetings Act? The purpose of the Open Meetings Act is encouragement of access, encouragement of participation. You have nothing to hide, right? So why not post them? If you don't post them and you post everything else, then members of your community might be like, hey, why don't they post the meeting minutes? What's going on there? So again, building trust, right? Building trust is posting your minutes is an excellent way to show your community, hey, we got nothing to hide. You find out, who is responsible to post the meeting. Make sure that's clear. Is it the secretary that's responsible? Do you have the library director do it? Make sure that, again, in your, you should, as part of your bylaws, have how your meetings are conducted. You should have how your minutes are handled. And then when, obviously you post them 8 days after the draft is posted, 8 days after the meeting. Within 8 days, the final is posted. You have up to 5 days after they're approved in an open meeting to post the final. Either, again, in public, like in physical, or if you're going to post them online. Do you have to put them in both places? Not necessarily. If you're going to choose to post them online, and you have a way to ensure that they're maintained, that they'll be saved, and there is some records retention policies on electronic data, then you do not necessarily need to keep them in print. But confirm that with your attorney. The statute does say to keep it at the place where, at your place of business. But obviously, if you have computers in the library, they are at the library. What do rules not cover? So your rules can't cover, obviously, like I said, registration to enter a public meeting. You cannot limit attendance at a public meeting. You cannot limit on the number of times a member of the public can speak. So if a member of the public wants to talk and they have their 3 minutes, and then they come back next week and they want to talk again, you can't limit that. They can come back and talk as many times as they want. You cannot restrict photography or recording. So again, if your library is involved in a controversy, or some other reason, a member of the public comes to your public meeting with their cell phone and spends the whole time just recording you, that is okay under the law. That is specifically permitted. Now, the person can't walk in front of everybody and block views to get their shot. They can't lay cords everywhere. So if their recording or broadcasting is inhibiting other people's ability to participate in the meeting, then that would be a problem. Or if they're causing a public distraction, that would be a problem. But if someone is just sitting in a chair, holding up their cell phone and recording, that is perfectly okay. And there's nothing the board can do about it. And no one has to ask permission because it is a public meeting. They can also be live streaming it on Facebook or Instagram, and that's also perfectly fine. Managing a public meeting. So and this is just kind of wrapping everything together. So when you talk about, okay, how am I going to keep this under control, and how do I run this efficiently and make sure I'm doing everything I'm supposed to be doing? So some tips are to, as we talked about, the rules that you establish, display them, right? So post them on the wall or have handouts so that everybody understands what the expectations are. Follow your own agenda, right? So make sure that if you have an agenda, you're sticking to it. And like I said, you can change it in the meeting, but stick to it once you have your final agenda. Any documentation handed out to the board members during a meeting should be available to members of the public. So if you have an agenda, have a stack of copies available for members of the public to pick out. If you have a draft budget, have a copy of the budget available. If you have a written director's report, let that be available. All of these items are public record. So any member of the public could FOIA them anyway, right? You're not handing out, employee personnel records or patron records at a public meeting. Anything else is public record. Now, you don't have to have like copies of bills and stuff that are being approved, but if you have a financial report that's a spreadsheet, have a couple copies of that available. Not everybody will want one, but if someone may. And again, having this transparency builds trust. There's no reason not to do it because all of that information is public record anyway. None of it is secret or private. Adhere to your own rules, right? So every member of the public body should also be following these rules, right? The meeting rules, the decorum rules. So if you model the rules, your public will follow. The members of the public will catch the vibe of the room and act accordingly. So if members of the governing body behave and follow the rules and act professionally and civilly, then most of the members of the public will too. So it's just like, think about like the same thing works with like, I don't want to say anything that's going to offend anybody, but like if you have like a classroom, right? I taught law school for 20 some odd years. And so if you have a room of 100 law students of varying ages, they're gonna get away with as much as you let them get away with. And that's true of like college students, it's true of high school students, it's true of elementary students. It's true of almost any group of people. So if you model the behavior that you want to see out of the public, then they're going to be more likely to do what you want them to do. But if you're all yelling at each other, then they're going to feel free to yell at you and each other. The chair, if you're going to be board president, then you have to be prepared to deal with some uncomfortable situations. And because that's the role of a board president. And in your bylaws, you should have the descriptions of each of these positions and what they're expected to do. So one of the board chair's primary roles is to rein in members, is to ensure that all of the other members are doing what they're supposed to be doing and to coach them. So the chair of the meeting should be able to retain control of the meeting, right? So it shouldn't get away from them by another member acting out or changing, doing something they're not supposed to be doing, or changing a topic or going off on a tangent. They need a calm demeanor, even if they're upset, right? So they need to be able to always be calm and firm. They should not, if board chairs should not hesitate to obtain assistance in terms of if you have someone making a public disruption. So, have relationships with your law enforcement, or if you have security in the library, with security, so that you're able to remove somebody or ask someone to leave if they're creating a disruption. You want to facilitate debate and discussion among board members. So if no one's asking a question, ask a question on something. If motions pass regularly in your board and there's no discussion at all, then there's a problem. Either everybody is kind of collaborating together and making decisions before the meeting, which is a violation of the Open Meetings Act, or nobody cares. And either way, that's a problem. The purpose of a public meeting is for people to discuss. So if you're trying to pick contractors for something, or you're debating whether or not to do something for facilities work, or there's a new position, whatever the motion is, there should be some kind of discussion. It shouldn't all have already been decided, because that's a problem. That's not how open government is supposed to work. In fact, the Open Meetings Act is specifically to deter that, to deter decision-making in private, in secret. That is not what's supposed to happen. So the chair should be encouraging discussion. So if nobody else asks a question, the chair should ask a question. And if a member of the body comes to the chair after a meeting and says, hey, I have a question and I didn't want to ask it in meeting, the chair should turn around and say, next time ask it in meeting. The question should not be saved for after the meeting. Wield that parliamentary power, learn those parliamentary rules that the board has decided to use, and wield them, right? So you can stop debate that is non-productive. You can, bang that gavel and get order back in among members. There's things you can do. You can cut somebody's time for debate if they're not acting appropriately. You can also keep the proceedings moving, right? Let's see, I covered pretty much all of this. You can have rules specifically for debate, and there's some really good ones in Robert's rules. There's also a special page just for small bodies that kind of cuts the rules down and makes them a little simpler. So that's an option too. Participants that are not a member of the public body. So, if either members of the public, library staff, even the library director should not be interfering in the discussion unless the board specifically asks them. If the board asks the director a question, or the board invites the director to participate, that's one thing. But the board meeting is for the board to make decisions. So anybody else is not part of the board and should not be participating in the discussion and debate. The public has public comment period. The board can solicit information from the director during the meeting if they wish. The director has the director's report. Any issue dealing specifically with business before the board, most likely whoever's proposing it should have gotten information from the director on this issue, or the board can ask during the meeting. But there should be no, participation from the peanut gallery, so to speak. So some sample debate rules. You can tell board members to address all their remarks to the chair, so that, again, this is useful if there's some contention, so that if you have two board members that dislike each other or are not working well together, you can say, okay, for debate and discussion, direct your remarks to the chair. And then, don't use the name of someone else. So if two people are arguing back and forth, what they're really doing is they're telling the chair instead of fighting with each other. You can determine that the members have to abide by existing behavior and ethics rules. And if they don't, then they're subject to whatever consequences the bylaws provide for. You can say, okay, each debate, so each issue that we're going to discuss gets X number of minutes of total discussion. And that's it. After those minutes are up, we're closing the debate. And then that, again, streamlines your meeting, so you're not there forever. You can say that the member that brings the motion gets to speak first. You can say each speaker has a certain amount of minutes to make a statement, so that, again, everybody gets a chance to speak. And then if someone wants to rebut or respond, they get X number of minutes. You can limit the number of times someone gets to respond. You can say members cannot give their allotted time to somebody else, right? If you're going to speak, you get time. If you don't want to speak, that's fine, but you can't give your time to somebody else. When their time is up, if you're giving them 3 minutes to speak, when the 3 minutes is up, they're done. They don't get to say anything else. And you bang your gavel, and that's it. And then you can say, okay, the chair can end the discussion if truly nobody has any remarks. For maybe it's a very simple motion. Just all of your motions should not have no commentary period or no discussion period. But, there may be one or two that do not need it. If you're in doubt, so if you have a question, remember the purpose of public meetings and err on the side of transparency. If you're ever accused of violating the Open Meetings Act and it goes to court, within the law, it says that the law should be construed on the side of transparency. So what that means is if the judge looks at it and says, well, this could kind of go either way, the law says you have to look from the standpoint of encouraging transparency. Take a look at your bylaws. Make sure your bylaws are reflective of the current situation of your library and your board. Make sure your board president is prepared for everything that they have to do. Make sure that they're trained if they need it. There's lots of training available through Library of Michigan and through other entities like MSU, like the Michigan Municipal League. I'd be happy to pass on some trainings and some information that I have on what they can take, but there's lots of opportunities out there to gain some skills in some of these difficult duties that a board president has. All members should be prepared to self-police and support each other in maintaining order. And if there's a controversy, so if there's a fight or if there is public disruption, make sure that you've had a conversation with law enforcement so that they know when you call what the situation is and what they would respond to. So again, training, all board members should get a board orientation, all should get refresher training, all should get mediation, conflict management, and parliamentary training. Get assistance. Library directors, Library of Michigan, cooperative directors, United for Libraries from the American Library Association. We have a membership. Library of Michigan pays for every library to have a membership. The resource pages will have links, and consultants. You can get help with all of this, how to set up your bylaws, how to, structure your public meeting. If you're having a particular issue with some problems going on in your board, all of these people are here to help you. Okay, thank you. I see I went to the very edge of time. This is a topic I'm very passionate about. Please don't hesitate to contact me if I can offer you any assistance or information or support. You will get a copy of the slides. I can see that there are some questions in the chat, so I will go through those. I will answer them in print, and I will make sure all of you get a copy of those answers. If anybody has any follow-up, you can certainly email me. I'm going to stop my share. Thank you very much, everybody, for being here. I will address the questions in chat, and I hope everyone has a really, really wonderful rest of your weekend. Thanks.